All right.
No, Judge.
With that, Mr. McKeska, would you please begin the announcements?
Yes, Judge. Drake McCusker, attorney for the department. I'm covering for Emily Kyler Green.
Jimmy Dresden Mitchell, investigation supervisor.
Stacy Turner, CPS investigator.
Kimberly Rios, family-based caseworker.
Deborah Fuller, attorney for the mother, Bailey Kitchens. Ms. Kitchens, could you please announce?
I'm Bailey Kitchens.
Cecilia Howing on behalf of the children.
Thank you.
And Your Honor, I had a conversation with Ms. Kyler Green previously on this case. Can I just confirm that with Mr. McKeska, that is what our agreement was? I'm sorry. I didn't realize that he was covering today.
I'm putting you both in breakout room 1 with Ms. Helrong and Casa. All right. You all had a chance to confer.
Yes, sir.
Do we have an agreement or do we need a hearing?
Judge, we have a partial agreement.
Okay. What is that?
So the agreement is that Ms. Kitchens will participate in services. The agreed services are that she will complete a psychological evaluation and follow the recommendations from the evaluation, and that she will participate in individual counseling. My understanding is that the prior agreement also included that she would complete a drug and alcohol assessment and follow the recommendations from that assessment. However, there's a dispute about whether or not the recommendations from that assessment are appropriate in the case.
And that's, Your Honor, where I have an issue with that. We had this agreement that she would do the OSAR, complete the evaluation, and that she would follow the recommendations. She already did that service, and it recommended outpatient. She's already started outpatient, and now the ad litem and the department want her to do inpatient. My agreement, it was on November 7th, was, you know, what Mr. McKeska said, the psych, the OSAR, drug testing, and counseling. And that's the agreement I had with my client. And she did the evaluation. Even though this case was pulled from being the TFF case and made a court-ordered services case, she went ahead and started the service and did her evaluation.
Your Honor, I can let the court know. From the time I was appointed at the end of October, I made it very clear to the department my concerns about outpatient for mom. This was initially a TFF for in-home parenting. I have met with Ms. Kitchens and also have been very clear with Ms. Fuller. My concerns are this. Ms. Kitchens already completed successfully outpatient treatment about a year ago. The facts of this case are that she got involved in a motor vehicle accident.
Your Honor, I would ask that she not go over the facts. We're going over the services, and you've already read the affidavit.
One at a time. One at a time.
Go ahead.
Well, before we get into any evidence,
Sure.
I mean, actually, and the only thing you're just trying to make me aware of what's going on. I want to ask a couple of clarifying questions. The OSAR recommended, is there any dispute that the OSAR recommended outpatient?
No,
I
sir.
have not seen the OSAR, Your Honor, but I'm not going to dispute that. I do have concerns as to whether it was appropriate.
And Ms. Rios could probably address that. I mean,
well, let's start there. Let's get a little evidence from Ms. Rios. Ms. Rios, have you reviewed the evaluation and the recommendations from the OSAR provider?
I have not reviewed the assessment. I just received those, and I'm happy to share them with the parties, Your Honor. I did have a verbal conversation with the provider and learned some information through that, and it was just that they recommended outpatient services and that she would be required to do group sessions twice a week for 2 hours and then an individual session once a week for 2 hours.
Does Miss Kitchens have a job right now?
No, Your Honor.
Miss Kitchens, let me ask Miss Rios, okay?
Okay.
Have you tested her recently?
No, Your Honor, I have not.
When was the last time she was tested?
I cannot attest to any time in investigation stage, but so far in my stage of service, I have not tested Ms. Kitchens.
So we've got a recommendation for an outpatient, and then we don't have any confirmation that she's currently actively using. Correct?
Correct.
Yes,
And
Your
my
Honor.
understanding is that an inpatient facility won't take you unless you're actively using. Is that correct?
My understanding, Your Honor, is they do have to meet that criteria.
Your Honor, it's my understanding this was alcohol, not illegal substances. That was the concern.
But it's still, you have to be actively, engaging in the overuse of alcohol as well to get into a treatment program.
Well, I don't want to stray too far away from where we are. Where we are is we had a TFF case to begin with. TFF case was non-suited. Now we've got a court-ordered services case. And mom has done an OSAR voluntarily. And it came back with a recommendation for outpatient. That's where we are. So, if you're all proffering to me right now and you want me to make a decision, I will. But if anybody wants to put on any evidence before I do so, we've got a couple minutes. Does anybody want to put on evidence?
Yes, Your Honor.
No, sorry, go ahead, Sue.
Let's be expeditious about it, please.
Yes, sir. Ms. Have you had an opportunity in preparing this case to review the affidavit in this case?
I have.
Have you had an opportunity to review the records in this case?
I have.
Are there concerns regarding outpatient for mom at this time?
Yes, there was some concerns regarding outpatient.
Can you advise the court when she, what the CPS history is with this particular parent?
So there is prior family-based cases where outpatient was completed and we're back involved again. Drug and alcohol is a concern again.
Okay, can you tell the court when she successfully completed her outpatient treatment?
I want to say it was a year ago. I don't have dates off the top of my head for that.
Okay. And reviewing the records and the allegations here, can you tell the court what happened and what brought the department's involvement again?
So the department became involved due to concerns about a car accident where young children were involved in the accident as well. Mom was driving a vehicle.
Your Honor, object to Ms. Rios testifying. She doesn't have personal knowledge of
Your Honor, she's
the
testifying.
investigation in this case. She's a family-based worker. She did not conduct the investigation.
I can call Ms. Turner, but we have the affidavit already on record.
Ms. Rios, are you testifying to anything that's outside of what's in the affidavit?
No, sir, just from the affidavit and being custodial of records, going through documentation.
Objections overruled. You can answer the question.
So there was an accident where a vehicle did a U-turn in front of her, and she hit the vehicle. She sustained injuries. There was a 6-year-old child in the back seat who was not buckled properly or restrained properly in a booster. He sustained injury to his spinal cord. And there was another child in the vehicle who was in a booster who was restrained properly. Going to the hospital, a drug and alcohol test was done, and it was shown that Ms. Kitchens was positive for amphetamines and also alcohol.
What was the blood alcohol level?
0.111.
Okay. And are you familiar with your training, knowledge, and experience as to the legal level in which for intoxication and driving?
Just enough that in the report indicated it was over the legal limit.
Okay. So you're not familiar that the legal limit is 0.08?
Yeah, well, I am familiar with that, yes.
Okay. I have nothing further for this witness.
Mr. McCaskill, cross.
I think Ms. Helrung covered it, Judge, for the interest of time.
Ms. Fuller.
Ms. Rios, you said that you haven't tested her. When did you get the case?
I received the case. I'm sorry, I'm drawing a blank on that.
But the incident that you referred to earlier was in August, correct?
The incident I was referring to, yes, ma'am, was in August. I received the case October the 23rd.
And so since August, if the mother hasn't been tested, no one can testify today that in the over 3.5 months that she's tested positive for anything.
That would be correct.
And you had an opportunity to review the OSAR. When did you get the OSAR? Or Hecata's assessment?
I received an email stating they needed information sorry, let me backtrack. I received an email stating that they needed the 2054s or service authorizations for Ms. Kitchens to receive therapy. And I had indicated that I had not received a report stating what the recommendations were. And so Mr. Craig at Hecata sent me the assessment on, sorry, I'm trying to see what date this was. On the 20th. And it was, we also had a verbal conversation at that time when I called him about the service authorizations, seeing what those recommendations were and what service authorizations were needed. And that's when he told me what the recommendations were.
And when you had sent in the referral to 2054, didn't you explain your concerns and discuss the incident in August and let them know what the department was concerned about? So they had that information when they were doing the assessment with my client.
Correct. I had that conversation twice with them.
So they're the professionals in this case, correct, Ms.
That's
Rios? And so their recommendation, based on all the information that you provided, which would be the accident, the alcohol levels, and the information that my client provided, they recommended outpatient.
That's correct.
And so today, you're here today to say that asking the court not to follow the recommendation of a professional and go with inpatient?
I just have concerns that outpatient's being requested again.
But Mr. Craig's the professional in this case, right?
Correct.
Okay, I'll pass the witness.
Your Honor, may I just ask a follow-up question?
Yes.
Do you know why they recommended outpatient? Was it because they didn't have enough information or because the mother said she would not do inpatient?
No, I know it's not.
I'd object to that cause for speculation, Your Honor. My client never said she wouldn't do inpatient. She said that she would follow the recommendations.
It was a question. That's all I'm asking is why he made that recommendation.
Well, she's asking for her to speculate why.
I'll sustain the speculation objection.
Okay. Did you speak to the OSAR evaluator?
I spoke to his boss, not the evaluator himself.
Okay. Did he tell you why they were recommending outpatient?
He did not.
Okay.
Any other questions?
No, Your Honor.
Any other evidence?
No, Your Honor.
All right. Is that the only other or the only issue in dispute?
As
Yes,
far
Your Honor.
as
My client agreed to the psychological, to counseling, and to do the assessment. She did the assessment right away, even prior to this hearing, so she could get that set up to determine what the recommendation was.
All right.
And I believe there's also the agreement for the ongoing random drug testing and alcohol testing.
Yes.
All right. With the exception of the disputed part, which I'll rule on here in a moment. That's your understanding of the agreement, Ms. Fuller?
Yes, Your Honor.
Ms. Elrung?
Yes, Your Honor.
Ms. Kitchens, you heard all of that was agreed to. Is that the agreement you made?
Yes, Your Honor.
Did you have the opportunity to discuss that with Ms. Fuller?
Yes, Your Honor.
Did you make that agreement voluntarily?
Yes, Your Honor.
Were you forced in any way to
No,
agree to that? Are you asking the court to adopt and approve the agreement today? Make it an order?
yes, Your Honor.
Okay. Then I will find, actually, let me back up a step. Miss Rios or Miss Turner, which one of you is more appropriate to testify as to the affidavit?
That would be me, sir.
Miss Turner, you've heard the terms and conditions of this agreement, notwithstanding the disputed inpatient or outpatient. Do you believe the remainder of the services are appropriate and in the best interest of the child?
Yes, sir.
And are all the facts and statements within your affidavit true and correct?
Yes, sir.
You believe it's in the best interest of this child for this court to order Ms. Kitchens to do these services, to address the concerns that brought the child into the care of the department, or excuse me, that brought the child in front of the court?
Yes, sir. Absolutely.
Right. Do you believe that there's sufficient evidence to satisfy an ordinary person of ordinary prudence and caution that abuse and neglect has occurred, or a substantial risk of abuse and neglect or continuing danger to the physical health or safety of the child caused by an act or failure to act of the parent requires services to be necessary in this case?
I do, sir. Yes.
Okay. Then I will adopt and approve the agreement. I will find that Ms. Kitchens was served by personal service on November the 14th, 2023. That she has agreed to, and the court will order her to participate in psychological evaluation and to follow any of the recommendations from it, to participate in individual counseling, and to submit to random drug and alcohol testing. I remember reading this affidavit, and I remember the TFF case. I share the concerns of the department and Ms. Hellrung regarding your use, Ms. Kitchens. But at the same time, there was an agreement made and there were recommendations made. And I'm not going to go behind what the professionals said, and I'm not going to go behind what the original agreement was. So I'm going to honor that. I'm going to allow you to do outpatient, but I'm going to caution you very seriously that I'm concerned whether it's enough. And so I'm going to watch this case closely. Our next hearing is set for February the 9th, 2024 at 11 a.m. February 9th, 2024 at 11 a.m. That's 3 months from now. That's a long time. So I'm going to order Miss Rios to get me a status update on the drug and alcohol testing and her participation. I'm going to make is part of her participation, Mr. McKeska. I didn't hear it. Is it NA AA classes?
I believe Ms. Rios said the recommendation was 2 hours of group a week, 1 hour of individual a week.
I want to make sure she's doing that. So Ms. Kitchens, I'm going to have Ms. Rios update the court in 1 month as to what your progress is. I'm going to tell you right now, if you're not progressing well, I'm going to order you to inpatient.
Okay.
Okay?
Okay.
Deal?
Deal.
All right. So that'll be the order of the court. And Ms. Kitchens, I want you to understand, this is a required participation case.
Yes.
Your children are not being removed from you at this time. But if you don't participate in this and you don't do what you've agreed to do and what you've been ordered to do, they might be.
I understand.
That could happen.
That won't happen.
Let's not get to that point. All right. Anything I failed to address?
No, Your Honor.
No, you're
Okay. Thank you all for your time and your service. If nothing further, all parties are excused.
Thank you.
All right.
Judge.
Mr. McKeska, would you please begin the announcements?
Yes, Judge Drake McKeska, attorney for the department.
Kim Coffey, Belong Adoption Specialist.
Kathleen Savage, attorney ad litem for the child, Your Honor.
Annette Lucas, guardian ad litem CASA for the child.
Amy Harding, Hilton Chicasa supervisor.
Martinez, adoption supervisor.
Thank you. All right, we're here on Miss Savage's motion to place Madison, and I've reviewed the motion. I don't know what would be my understanding is that the department is a situation where the department can't necessarily agree to it.
Yes, Your Honor.
Okay, so Miss Savage, I'm gonna kind of rely on you to tell me if you think that we need to present evidence or we can proffer on this.
I think we can proffer, Your Honor. Or I can call Miss Coffey very briefly and just get her to give the court some information, however the court would like to move
Judge,
forward.
I have no objection just to the proffer of evidence.
Okay, then go ahead, Miss Savage, and if I have more questions, we can elicit those from Miss Coffey.
Okay, Your Honor. As the court's aware, Madison had gone on run at I believe at the end of October, early November. She was picked up after about 10 days being on run. This was not the first time she had gone on run. It's probably number 6 or 7. When she was located by law enforcement, she was with a felon who was 20 years her senior. At that point, Madison made it very clear anywhere she went, she would run. The only place that she would not run from was her biological mother, Miss McCain. We made the decision to place her there about 2 weeks ago. Madison has actually been doing really well there. She's listening to her mom. She's going to school. This is the most quiet her case has been in a long time. And so we are pushing for that placement to be an official approval. Obviously, the court is aware Ms. McCain has significant CPS history. This is why the department cannot make it an approved placement on their own. However, Ms. McCain's circumstances have significantly changed. She's sober, she's working, she's stable, she's willing to engage in counseling and any other services required of her. So I do believe that this placement is in Madison's best interest and would ask the court to approve it. Again, we've got a 16-year-old who is very stubborn and has made it very clear if she's anywhere else, she will go on run. And she has shown us on several occasions she's very capable of doing so and finding people to help her along the way. So I do believe this is the placement that keeps her safe, and at least we know where to find her and can check in on her. And so I do believe that this is in her best interest, Your Honor.
Mr. McKeska, response.
I think that Miss Savage addressed everything fully, Judge.
Okay. What's Costa's opinion on this?
Ms. Lucas, would you like me to respond?
You can add in, sure. I was just going to say, I think the only, the only problem we had, or at least in my opinion, was that where she was going. And I understand that there, I'm hoping that Belong or whoever will set up a lot of things, just like if she was going into any foster care. And that would be, pretty good monitoring. Is there going to be drug testing? Is there going to be consequences for not attending school? Is therapy going to be, just all the questions I think that we had into any placement. And I think that we were caught a little by surprise by the hearing being strictly for Heidi. I thought that originally it was a temporary situation. And like Kathleen said, it's, I think for Madison, this might be the one place that she does adhere to what she's supposed to do, because this past 6 months has just been horrible. Absolutely. For everybody involved in this case, it's just been tragic. And so I think we just had some concerns about that. Is the home going to be vetted? Is, what's going to happen as far as people visiting? Is it, just all those things that I think we would have with any foster placement. And we don't know a lot about this foster placement. Heidi does happen to be her biological mom, but we all have case history with that particular situation to start with. So I think that we did have just, and if Amy maybe wants to explain this a little better, I think the other question about, she does have 2 brothers. that have been adopted and live out of state. And Madison has, I don't know how much contact she's had, not very much recently, but the fact that the two boys were around Heidi, obviously, and around the grandmother who lives with Heidi and Madison, and where that will, you know, what's going to happen with that situation. I'd hate to see the boys go backwards, because when they did have visits previously with mom, it was traumatic. It was, you know, nightmares at night. It was bedwetting, and you know, we just hate to see that regress. And so I think that was just another issue that we maybe wanted to look at as well.
Your Honor, if I can just expand for a moment, I think that we would like to, because the law has changed and there's potential for reinstatement of parental rights in this situation since circumstances have changed. I think we would like to see a family group conference or a meeting of sorts to really line out for Heidi and Madison what the expectations are. You know, before you were on the bench, you and I did a case together where we did return the teenager to her mother after parental rights were relinquished. So this is not something that I'm unfamiliar with. But I'd like to make sure that both of them understand that they have some skin in this situation, and that I think, you know, they get one bite at this apple, and we want to make it work. So I'd like to make sure that we're all on the same page, and that they are fully invested in what needs to happen, because I don't think it's out of the realm of possibility that we could be coming back here in 8 months or so and asking for a situation where Madison could be out of foster care before she turns 18. That would be my goal. But I think that we need to have some more structure around this situation so that we can get them to that finish line, because I do think that's what Madison and Miss McCain would like as well.
Thank you. Anything else from you, Miss Savage?
No, Your Honor, I did file a motion for a name change for the child. I don't think anyone has any objections. This was a direct request from Madison. I can have her file an affidavit approving that name change, but I just wanted to put that on the record to see if the court would be willing to sign an agreed order once that affidavit is submitted in the court's file.
I would be, if everybody signs it. I would be inclined to do that. Just make sure Madison signs it.
Yes, sure.
She wants to meet with me about it, that's fine. Ms. McCain, can you hear me?
Yes, sir, I can.
You understand that, you know, we've got a lot of history. I've known who you are since January of 2021.
Yes,
sir. So, very familiar with this case, and I've been overseeing the cases to the boys and Madison for a long time now, over 2.5 years.
Yes, sir. And I have made a lot of changes over those last few years, and I'm very willing and excited to show you that I'm not that same person anymore.
Okay. And I believe that can happen. I've seen it happen.
Yes, sir.
I've got firsthand experience with it, both as an attorney and as a judge. So
yes, sir.
I'm very well aware that people in this situation can change, and that the exact opposite of what we expected to happen can happen, and often can be much better than what we expected. So I needed to hear you say what you just said, and I need you to understand that if I grant this motion, it's going to come with some conditions that I fully expect you to follow.
Absolutely, Your Honor. I will do anything that you ask me to. And I know you've heard that from me before, but I will show you this time with my actions instead of my words.
Well, that's good to hear. All right. Because at any time I can take it back, and I don't.
Yes, sir, I understand.
I don't want to do that. I don't want to do that to Madison. I don't want to do it to you. I don't want to do it to anybody else that's in this room that's been working so hard to get her to a place where she's okay. She's got a long road ahead of her to get over a lot of trauma.
Yes,
She's
sir.
making decisions that scream, I'm traumatized and I still haven't gotten the right help yet. That's what she's doing on a daily basis.
Yes, sir.
So I feel like her being with you at this time and her wanting to be with you at this time, is a viable solution, provided we set some parameters in place. And the other thing I want you to be aware of, it's been 2 weeks, right, Miss Savage? She's been there for 2 weeks.
Yes, Your Honor. Miss Coffee has a specific date. I don't have it off the top of my head, but it's been roughly 2 weeks.
All right, so the honeymoon's almost over, Ms. McCain.
Yes, sir.
Reality is about to set in.
Mm-hmm.
Things are going to get more difficult. So you're going to have to start being mom for all intents and purposes, whether it's good or bad, because the honeymoon period is just about over. So I'm going to grant the motion. I'm going to grant the motion. I'm going to order the parties hold a family group conference within 14 days of today to come up with parameters that you all feel are appropriate for Madison and Heidi to follow within that environment. I don't know exactly what's going on in that house, so I'm not going to sit here and make orders that I don't have all the information for. You all know, you all can figure it out. But I want there to be, this is my 2 requirements. I want there to be a heavy emphasis on counseling related to sexual trauma and appropriate behaviors for both Madison and Heidi. I'm requiring both of them to go to that kind of counseling. Together, separately, whatever works. Probably separately, and maybe do something together at some point. But that's a big reason why we're sitting here today, and it needs to be addressed head on. I'm going to order Belong to monitor weekly for the first month, bi-weekly for the second month, and then once a month after that. Obviously, Casa and Miss Savage can also monitor on their own. So, Miss McCain, there's going to be a lot of people in and out of your house.
Yes, sir.
And they don't have to work around your schedule. They will, because they're professionals and they're respectful, but you've got to be able to accommodate those visits and make sure that they can get in and see and do whatever they need to see and do. Okay.
Yes, sir. Absolutely. My work is very flexible. If I can just tell them, a day before, hey, I need to not be here at this time, they're very willing and flexible to let me to move my schedule around as needed.
Okay. I want to make sure Madison is attending school regularly. Talk about her grades. She's got accommodations, so I want to make sure that those continue to be met. If she needs art, we need to get that art done.
I did. I had a meeting with the school, and we have a second one set for January. I want to say 3rd or 4th, to go over the because she was previously in like a special education program when she was in East Bernard, and so they're going to continue that for her English and her math, I believe. And so we have a meeting set up to just make sure that everything that she needs is going to be implemented there to start back after the Christmas break.
All right, that's good to hear. Ms. Coffee, you all be in conversations as we move forward as to if there comes a point where it's appropriate for Ms. Schaefer to become the educational decision maker and medical consenter. I don't think that that's today. I think we've got to get into this and see how things go. But I have a feeling that at some point she's going to need that. And so when you all feel like it's appropriate, send me an order. Anything I failed to address?
Judge, just quickly, I have it monitor heavily or weekly for the first month, bi-weekly the second month, and what was the order for the third?
Once a month. I mean, she's going to do that anyways. That's what Ms. Coffee does anyways, right? It's every 30 days contact.
Yes, sir.
Yeah. So I just want the first 2 months to be a little more intense.
Okay. And then do you want Ms. Savage or myself to draft the order? I vote Ms. Savage.
I vote Ms. Savage too.
What? You're taking such great notes, Drake. I will do it.
All right. Okay.
I get to counting.
That's your penance. No, I appreciate everybody here so much. And Ms. McCain, I know you haven't been in all of our hearings for quite some time, but this is a great group of people that's working really, really hard for your daughter. And
Yes, sir. I'm very well aware of that. And I
Okay.
cannot even explain how grateful I am to every single one of you.
all right. So when I make these orders, I'm making these orders knowing that they're all depending on me and you to make the right decision because they've got a lot invested in your daughter. So,
Yes, sir.
okay. All right. Well, thank you all for your time and your service. If nothing further, all parties are excused. Have a good afternoon.